Case number 17, People versus Christopher Nicholson. Ms. Davison, good morning.
Good morning. May it please the Court, Mary Davison for the appellant. May I have 2 minutes, please, Judge Prater? Your Honors, this case presents the Court with 2 issues of pure law. The first is whether Supreme Court erred in its role as gatekeeper for admitting rebuttal testimony by allowing testimony of the People's rebuttal witness with respect to a very narrow scope, that is specifically whether the defense witness was untruthful when she testified that she maintained a relationship with Mr. Nicholson, a friendship-based relationship with Mr. Nicholson between 2003 and 2008. The second pure question of law is whether the majority at the appellate division committed a Concepcion LaFontaine error when it drew what it referred to as a permissive inference that it could it would allow that testimony because it went to the issue of bias or motive to fabricate, which, as the Court is aware, is never collateral.
On that score, would you agree that the trial court made a finding by not sustaining the objection to this testimony, the rebuttal testimony, that in fact it was relevant and not collateral?
Which one, I guess, is the question in response. There were 2 objections lodged. One was that it was not relevant. Pardon me. One was that it was not relevant. It was not relevant. One was that it was collateral. It was collateral. And so
but the trial court found otherwise. The trial court found that it was relevant and it was not collateral. Otherwise, it wouldn't have admitted this testimony, correct?
I think we're limited by the record, Judge Stein. The trial court found, regarding that limited testimony, its proper rebuttal.
Right. So in finding that it was proper rebuttal, it necessarily found that it was relevant and not collateral. That's what I'm asking. It didn't articulate that, but then again, trial courts don't always articulate their reasoning for making a ruling. So why then would the appellate division, explaining why that was a proper ruling, be committing a LaFontaine Concepcion?
I think you have to start with the premise that the Supreme Court erred in finding that it was not collateral. It was collateral. It by the very language of its ruling at the trial court level, it limited the scope of that rebuttal testimony to.
That's your first, I'm sorry, that's your first issue.
Yes.
I'm talking about the LaFontaine Concepcion question and whether it's in fact a different basis or whether it's the same basis. The appellate division agreed with the trial court that it was relevant and not collateral and didn't make some other finding.
Respectfully, Judge Stein, I think the question infers the Supreme Court was correct in its ruling, and it was not. I think the appellate division committed the LaFontaine error because it tried to salvage an incorrect evidentiary ruling by substituting in the what would have been a permissible basis, which was bias or motive to fabricate.
Isn't Judge Stein correct that if there is no articulation by the court, then express articulation, you can look at the record as you indicated, counsel, and see that the trial court inferred from the arguments made on whether this rebuttal testimony should be allowed that it was relevant and not collateral, particularly when the prosecutor said, I'm going to cross-examine on, this relationship or whatever she said regarding that.
Well, what she said was a very specific.
She could have been a lot more articulate, I agree. She could have just said, I want to find out more about this relationship. I think that the motive here is not that they're friends, but that they have a romantic relationship. Granted, the prosecutor did not come forth with that express statement of why she wanted to call this rebuttal witness, but she did reference her cross-examination of this Miss Morenzik, I'm not sure if I'm pronouncing
I think
her
that's
name
correct.
correctly, Miss Morenzik, where she tried to bring out that the relationship was more than a friendship between Miss Morenzik and the defendant.
If the prosecutor had offered it for bias or motive to fabricate, I don't think we'd be here today. She did not. She offered it for purposes of truth. She used the word untrue, and the court.
The question is, though, and this is what's difficult, I guess, but
It is
interesting
difficult.
about this question. It seems that the rebuttal witness was it's almost like you're both correct. The rebuttal witness was offered to show that they had, that her testimony was tainted by a romantic relationship, and therefore that he, though it wasn't articulated as clearly as could have been, you're right about that, but that from the people's point of view, it was biased. She was a biased paramour in a romantic relationship with this person over a period of time. On the other side, the defense says it's an impeachment. You're trying to say that she lied. But was she lying about her romantic relationship and therefore biased, or was she lying about something else? So when they're both there, in other words, both bias, which benefits the people, and impeachment, which is clearly in your favor, and both those principles are there, it seems to me it's very difficult for this court to reach down and say, not having watched them and not having been part of it, oh no, that rebuttal witness shouldn't have been there.
I think the answer is found in People v. Williams, where this court found in 1959 that when the proponent of an offer of proof is unequivocal, maybe that's not the right word, is unclear, is probably a better word, it's their problem. It's not the problem of the person who is in response to the testimony that's
Kind of
being
unusually,
offered.
though, we have the benefit of having read it, and it seems, having read the testimony, it seems you're both vindicated to me also. So it's, I don't see it as quite that much of a slam dunk, but okay.
Can we perhaps think about this a different way? Friendship is bias.
Yes,
Witness is bias. There's no ifs, ands, or what's around that.
and she admitted that bias.
She admitted bias. So when the prosecutor says, I want to put in a rebuttal witness, the friendship is not true, the rebuttal is still about this bias. I mean, how is it not about bias? The cross, as Judge Abdul Salam has already pointed out, was very much geared to show it's more than a friendship, which is to say the prosecutor's goal here is to show that there's not just a friendship bias, which may not perhaps motivate someone to perjure themselves on the stand, but a romantic bias may very well drive someone to perjure this particular witness to perjure herself on the stand. And that becomes very obvious when you look at the cross, that this is what the prosecutor means when I say that's not true. That's not the level of her bias.
Well,
Why is that not an appropriate way to look at what went on during this trial and on this trial judge's call about this proffer?
several responses to
Yeah.
that. First of all, when she admits the bias, it's over. It's done. There's no place left to go with respect to the friendship.
Well, other than, as I say, the prosecutor may be very much interested in making very clear that she's not being really candid on the stand about the scope of the bias.
But their problem is she didn't articulate that. And under,
She being the prosecutor.
She being the prosecutor, yes. And under Williams and under Innes as well, she has to.
Well, those cases, though, we're talking about whether she preserved, in other words, if the court had not allowed the evidence in, and then her failure to, the prosecutor's failure to articulate the reason would leave her argument unpreserved on appeal. We're not talking here about preservation. We're talking here about not how the proponent did or didn't articulate it, but how the trial court did or didn't articulate it.
Or secondarily, how the appellate division was allowed to review it. And I direct the court to 47015 subdivision 3, which is my understanding, the appellate division's fact-finding authority. And that section of the statute very clearly says in reversing or modifying a conviction, they have the authority to make facts. They did neither in this case. They affirmed. And so I would submit that they didn't have the authority to draw those inferences in this particular case. I'd like to speak one moment, if I may, about the sex abuse accommodation syndrome witness. This presents an interesting question for the court, which has been touched upon in prior appellate cases, which is at what point does this issue become so much a part of the common fabric of our society that we no longer need that type of expert, if you will call him that. I wouldn't. But in this particular case, every single member of the impaneled jury who responded to the questions, and inferentially, all those...
There's the rub. Some of them never made a statement, correct?
But the panels were, that is correct, but the panel as a whole was asked, would anybody be shocked, and nobody responded affirmatively.
But they had different reasons, didn't they?
The panel members?
The ones who responded.
They answered the question.
But they gave a variety of reasons
Yes.
why they would
Yes.
not be shocked.
Yes, but
So why does that not mean that then they are entitled to this kind of a witness to be able to run through the various reasons?
Well, two answers. One is...
I've got one reason that I've articulated why I wouldn't be shocked, but you know what? I'm not persuaded in this case because I've not been given the opportunity to hear from this witness that explains sort of the range of experience that might result in a failure to immediately disclose the abuse.
The most obvious answer is that there's no indication it's beyond the ken of the jurors who were impaneled.
What about the testimony that a victim might act out violently or aggressively? How was that ever addressed with the jurors?
Well, there certainly were questions with respect to what would you expect to see, what reactions would you expect to see, and the jurors calmed all the fears of the prosecutor by saying, we don't have any expectations. It could be anything. It could be anyone.
In a pop question like that at a voir dire, unless you're delving into each juror's experience, nowadays jurors watch all of these TV shows, CSI, all these other things, and I think they have some kind of familiarity with what goes on in the criminal justice system. But is the prosecutor bound by those answers, even if the jurors do suggest that they may be familiar with a syndrome? Does that mean the prosecutor can't educate them on what the experts are saying about the syndrome as opposed to what the jurors think they know about it?
I guess the question is, what's the limit of that education? Where do you go across the line and become bolstering? Because extensive amount of time was spent on voir dire and educating the jurors. As attorneys, we know that's one of the functions of voir dire is to educate the jurors.
The thing is, I draw an analogy to a civil case. Everyone knows of a particular disease, cancer, something we've all had experience with in life, and most jurors have had experiences with it. But nonetheless, there'd still be a requirement for expert proof to go forward, to go into the details in the process, even though people are generally familiar, say, with the parameters of a particular disease. And I'm trying to see how that wouldn't apply here.
Even assuming that it did apply, the second layer here is that the admission of that testimony is always a matter of discretion of the trial court. And here Supreme Court, in its commentary, indicated that it had no discretion. I don't think Spicola and that line of cases had been decided quite at that point, but the Fourth Department certainly had decided Donk and other cases. And the Supreme Court said, I have to follow these cases, and the inference is it had no discretion.
Well, it may have concluded that if it didn't allow it in this case, it would have been an abuse of its discretion.
Again, that's not what Supreme Court articulated, and I think that we're left with what's on the record before us.
Thank you, Ms. Davidson. Mr. Kuiper, good morning.
Good morning, Your Honors. May it please the Court. Jeffrey Kuiper for the people. If I can start with the rebuttal witness, this is a mixed question of fact and law, and I think there's clearly record support for this being addressed to bias or motive to fabricate.
One of the things that had struck me was that if the ex-wife had a boyfriend who thought that she was useless, could the defense call him to say, she's doing this because she wants to get back at her ex-husband just like she tried to get back at me, so she's lying about the fact that this girlfriend was lying? Or are we getting collateral?
Well, if they can call a witness to show that one of our witnesses has a motive to fabricate testimony.
I understand fabricate. But
or a bias, sure.
She said this witness testified specifically that she has been friends with the defendant the entire time, including the time after she broke up with him and he was with his wife up to the present date. I'm calling this witness to rebut that statement, that they were friends this entire time. So that sounds collateral to me, you know, and if this witness, and if you're saying they can do that, I'm wondering if you can call the ex-boyfriend of the ex-wife to say the ex-wife is a liar, she's been lying forever. The reason why she's doing this is to get back at her ex-husband, just like she's trying to get back at me because we broke up last week.
Yeah, I mean, I think the problem with that would be that it's not based in anything. I mean, but I mean, if he can, if you know, if they can call a witness who will say, you know, I mean, I can't think of something, but where there's something definable, some actual extrinsic evidence.
No, what I'm suggesting to you is at some point you got to stop this. I mean, you got a witness that comes in and it says I was with him when they got tired, you know, and whatever. But she admits bias. There's a cross-examination. At some point you got to stop. And I saw no use for this. I mean, I didn't know what it added to the case. It seemed collateral to me. And then the argument is, if she was let in for one reason and the appellate division made a different decision, where do we go from there?
Yeah, well, I mean, I don't think that's what happened here. I think I certainly agree with Judge Abdus Salam that the prosecutor here didn't articulate her position particularly well. But when she's asked, when the collateral objection is made, this is collateral, her response is, I was asking about her present relationship. And then she says, you know, this lying about being friends all the time, this is a lie. Now, that is somewhat ambiguous. It's not particularly well spelled out. But you see in her summation what she does with it, what her point is. She doesn't argue she lied about whether she was friends with her at one point, so she must have lied about other stuff. She didn't make that argument. She makes the argument, you know, she's either secretly carrying on this relationship while the defendant's married, or she's lying about whether or not there was a friendship ongoing, and either. I'm sorry.
Counsel, Mr. Carper, are you suggesting that the ADA couldn't figure out what you really wanted this rebuttal witness for until she got to the summation?
No,
because
no.
she should have told that to the
She
trial
should
judge.
have said it better, absolutely. But I think you can see from what she's saying what she's thinking in the colloquy, and I think then in summation it becomes even clearer. And you know, because defense counsel says in the reply brief, well, you know, things change in trial, and maybe she changed her idea. Nothing changed on this point. The rebuttal came in exactly as she wanted it to. If she had called it just to point out a lie, she would have made that argument in summation. She didn't. She made the bias argument. And if I can address the Williams issue, too, because this stuff about you can't consider what happens later. Williams involved an offer of proof. Offer of proof is a term of art. There was no offer of proof here. An offer of proof is when evidence is getting excluded, and you have to. Of course, the colloquy is what's got to lay everything out, because the evidence isn't going to come in. You're not going to know what happens to the evidence. Here, the evidence comes in. It gets used. We can look at what was the purpose of bringing this in. We can tell what the purpose is. She uses it to show motive to fabricate bias by trying to argue that this shows the fact that she's lying about the nature of the friendship shows that she actually has a romantic relationship with her. So I don't think the appellate division was finding new facts or changing the ruling here at all.
The witness is already admitting bias in the sense of, yes, I have a friendship, I'm his friend, and talks about how often they communicate with one another, and it's been a long-standing friendship. That's already about bias. So doesn't the prosecutor have to do more than simply say, I want to show that's untrue? To really clarify, I'm still staying with this issue about bias.
I mean, again, I think she could have articulated it better, absolutely. But I don't think there's a rule that it has to be fully articulated in responding to an objection.
Well, don't forget it's a two-edged sword, and I could see the defense wanting to bring in witnesses similar to this to show that police officers lied, that police officers did not tell the truth with respect to some aspect of a confession or something like that, and citing this case and saying, you know, this is the case that the people argued, saying that we can bring in people to collaterally attack witnesses.
If the extrinsic evidence goes to motive to fabricate, if the inference from the evidence as to motive to fabricate and bias is a reasonable one, yeah, and so that requires some discretion by the trial judge in sorting this out.
When have you seen that happen?
I mean, I think the judge does it in this case. I mean, it takes him, wait, what's the timing? He's thinking about this. He's thinking, is this going to be collateral? Is this going to advance the issue of bias at all? I mean, the objections by the defense counsel are the proper objections to make, and the judge decides those issues. He considers them.
So you would say yes to bringing in the ex-boyfriend of the ex-wife who wants to say that she has a bias and a motive to lie about the girlfriend and the ex-husband.
Yeah, I think that would be proper.
But can we bring in the guy at the bar who knows that the ex-boyfriend, is a drunk, and he already told him that, he really still does love his ex-girlfriend, and the reason he's doing this is to lie about her, to get back at her, because she's trying to help the ex-husband with whom she had a relationship and is now mad at the girlfriend?
I mean, there might be a hearsay problem with it, but conceptually, I don't think there's a problem with it.
Why don't we bring in the bartender that says that the guy at the bar who's saying that this guy's a drunk is lying about the fact that this guy's a drunk because he wouldn't pay his drink? You see my point?
Right. Now, right. I mean, it has to be right. At some point, I mean, I suppose there would be some abuse to take it a different way, not have it that chain, but to bring in a rebuttal or a yeah.
Well, you got to roll your eyes when you're bringing in an ex-wife to testify about how a girlfriend is lying. I mean, I thought, what is anyone surprised at this? I mean, what are we doing here?
But this,
and it seemed to me all you're doing is bolstering and.
Well, but I mean, I think this is a critical defense witness.
It sure is.
And whether or not she's romantically involved with this defendant is very important to judging how to evaluate her testimony.
Well, let's say we believe it's error. Is it harmless?
I wouldn't try to argue here that the proof was overwhelming. So I think harmless doesn't work in that sense under Crimmins. But I would say that this, I mean, even the dissent at the appellate division says this didn't matter.
Right. But they were very worried about this collateral aspect of it, and I went to some length describing it.
But I mean, I think if this were to be determined to be error, I mean, I think this might be that kind of de minimis error that doesn't even require the harmless test. But I certainly would agree that I cannot pass the overwhelming evidence here. This was a credibility case. Absolutely. If I can address then just briefly the CSAAS testimony here. What happened in voir dire, I mean, I think it probably is true that a large section of the population now has some vague idea that, yeah, kids who are sexually abused don't necessarily always report on time. If that was what the expert here testified to, if that was the limit of it, then yeah, his testimony would have been unnecessary. He gives very specific testimony that's very relevant to the particular facts of this case, too, about how family relations affect the delay, about how violence in the relationship affects the delay. And his testimony is really very different from some sort of generalized I've sort of gotten the idea that maybe kids don't always right away report abuse. So I think this was properly admitted here, and I don't agree that the judge was saying that he was required to and had no discretion. He says he's required to follow the cases. He is required to follow the cases, and the cases tell him to use his discretion. I think he did that here.
Thank you, Mr. Kuiper. Ms. Davidson, is it a mixed question?
No. The question is, was the evidence admissible? The question is, if the evidence was, did the appellate division have the authority to draw that permissive inference to find that this is what the judge ruled on?
Or is it whether it was an abuse of discretion to admit that evidence?
I'm sorry, repeat that?
Or is the question whether it was an abuse of discretion to admit that evidence?
By Supreme Court?
Yeah, that's a little different from saying, is it admissible? I mean, if it's a discretionary determination, then we look to abuse, don't we?
If it was an abuse of discretion as a matter of law, then I would submit, because of the purposes for which Supreme Court admitted that particular evidence, I think it's very clear on the record. There is no record support for the appellate division's determination that this was for purposes of bias or motive to fabricate. The judge articulated it 2 or 3 times. I'm allowing it for purposes of showing that this individual did not remain friends with Mr. Nicholson from 2003 to 2008. That was the limit of the proffer. That was the limit of
Saying
the
that that's
ruling.
only relevant in the context of that witness because it shows she's a liar and therefore it's collateral, as opposed to showing that based on the cross that it's not just a friendship, it is a romantic interest.
She admitted her interest. She admitted the friendship. And in fact, the testimony that was properly adduced during the rebuttal witnesses'
I guess what I'm
testimony-
saying, if she's already admitted, perhaps I didn't get to this question before. If she's already, as you say, admitted the bias of the
Right.
friendship, what would be the value in putting up a rebuttal witness that says, no, they're not friends, other than to show there's another bias? The whole
None.
point of that is to show there is a bias, is it not? Why would a prosecutor want to undermine the bias that the witness herself has admitted to?
Here you've got a witness who says, I lived in this household during the period in question in the indictment. This wasn't going on. There weren't these horrific incidents late at night or early in the morning where the sexual abusive, assaultive conduct was going
All
on.
the more reason to want to show that she had a motive to lie, and it might be that she has a romantic relationship with the defendant and doesn't want to see him go to jail, not that they were just friends.
But think about what was adduced in the testimony. The testimony, if you read through it very carefully and cull out all the foundational objections and that kind of thing, is they had no contact in 2003, 4, 5, 6, 7, 8. That's the limit of the rebuttal testimony. And all that does is go to show that the defense witness was being untruthful when she said, I maintained a contact with him during this period of time. And so it is collateral. It has nothing to do with bias or motive to fabricate. She admitted her bias. That was the limit of proper cross-examination. It was reached. It should have been done. And Supreme Court erred by allowing this rebuttal testimony in. I think it's a red herring to say, look at the summation. As an attorney goes through cross-examination or through direct examination, things develop based on the answers that the witnesses give you. And as things develop, you take advantage of them. You feel that the testimony is being drawn in one direction or the other, and you go there. Because when you've got a witness who's saying to you, this happened or that happened, and you get the sense that they're hedging, you follow that witness. You can't say in retrospect, oh, this was a planned course of action. I would submit to you that this prosecutor didn't know what the defense witness was going to say until it was said. And she followed that course. Did she take advantage of it in summation? She did, but that doesn't mean that that's what her intent was, and it doesn't mean that that was what her initial course was. So, again, I'd submit this is not harmless error. The correct remedy here is reversal and remitter for a new trial.
Thank you, Ms. Davis. Mr. Kuiper.